30 minutes.
Okay, thank you so much for this organizing this webinar, and thank you, Audra, for agreeing to discuss the paper. This paper is with Burcu and Suhas. They are my very good colleagues and co-authors, and as the title suggests, the paper is about disclosure and lawsuits before the IPOs. It was marketed under a different name, but recently we have changed a little bit of the front end. You know, the paper doesn't change that much; it's just the title and some basic things that the introduction changed a little bit. But when we are talking about disclosure, basically what we will be mainly focusing on is the IPO registration statements. So the IPO registration statements are the basic form of disclosure before the IPOs, and they're filed and fully reviewed by the SEC. They're mandatory filings, so any company that's planning to do an IPO has to file these statements, and they're the primary source of information for any potential investor. So basically, it provides information about the company's operations, financial situation, risk factors, and it includes a detailed management discussion and analysis, which also includes some audited financial statements. Now, basically, when companies file these registration statements, what happens? I will quote this gentleman. He worked at Facebook and PayPal during their IPO processes, and he is a former CEO of the Reddit, and he also writes in these blogs. Basically, the question he's answering is what happens when the company is going public, and basically he says that it's a distracting process. Once the company files for the files its S1 filing, everybody becomes interested in the company, and there's a lot of news. Some of them are right, some of them are inaccurate about the company. And then what happens next is the lawsuits. So once the company files for an IPO, basically everybody learns about the company's financial situation, and the company starts getting all these lawsuits. Many of them are kind of frivolous. Things filed by patent trolls or perhaps competitors and employees and stuff. So we came across this idea actually through an MBA student, a former MBA student of mine. He was basically describing his company's situation. He was working at a startup, and he was basically mentioning that once they filed for the IPO, they started getting all these kind of frivolous lawsuits from their competitors who actually wanted to derail their IPO process. And we wanted to see if this was a kind of common thing that's happening around. And if you just Google, what you will see is basically news like these, like companies getting sued by competitors, patent trolls, ex-employees, and all sorts of other parties, their current employees in the case of Uber, for example, or, there are a lot of patent trolls also, again, involved in this process. And these lawsuits seem to be kind of suspiciously timed in a sense, as this, open table lawsuit, sites. Basically, they come right after the company files for its registration statement and before it does its IPO. So what we want to look at is, these lawsuits. So in terms of the registration filings, there used to be a relatively little managerial discretion about what the company wants to disclose and what it doesn't want to disclose. Primarily, the discretion relates to the disclosure quality, like the tone of what you're disclosing, and there's a little bit of a discretion in terms of the amount, as Audra's paper shows. Basically, what the companies can do is they can ask for redacting some of the information, like some material contract information, but everything that's filed with the SEC and all of the SEC's comment letters were made publicly available upon their filings. After the 2012 Jobs Act, what happened is the Jobs Act Title I actually provided a new category of issuers that are called emerging growth companies. And they did this because companies were concerned that the legislatures were concerned that the companies are not doing enough IPOs, mainly because of the proprietary disclosure costs and regulatory costs. So they wanted to reduce these costs a little bit, and they defined basically this emerging growth company category. And for these companies, basically, the Jobs Act provided several provisions that relaxed disclosure requirements and gave some discretion. Basically, the most notable provision in this Jobs Act was the confidential filing provision. Basically, the confidential filing provision allows companies to keep their registration statements and the SEC's communication with the company non-public until 21 days before the roadshow. To compare, before the Jobs Act, the average time between the filing of the registration statement and the IPO date was about, on average, 5 months. So this is a very significant reduction in terms of the amount of time all of this information, remains public. The Jobs Act also included several other provisions. They are relatively, smaller. They provide relatively small discretion, but they are still important. Basically, there are things like providing 2 instead of 3 years of financial statements, reducing the amount of compensation disclosure, and delaying compliance with certain regulatory applications. Now, in terms of the consequences of the Jobs Act and the confidential filings, basically, the evidence is largely consistent with what the disclosure theories would suggest. So when you disclose less, basically, it increases your adverse selection costs. And consistent with this, prior research shows that confidential filings and reduced disclosures under the Jobs Act are associated with greater underpricing and greater post-IPO stock price volatility. And this basically relates also to the prior findings that when you provide lower quality disclosure in the registration statements, you also face higher underpricing and higher and lower liquidity, basically. In terms of the benefits of these confidential filings and reduced disclosures, basically what we see is that approximately 89% of the eligible firms choose to submit their registrations confidentially. And this suggests that the proprietary disclosure costs were likely very important. And now that the companies are given the discretion, they actually choose to utilize the confidential filings. And just to be clear, most of the IPO firms are actually eligible because the eligibility cutoff is $1 billion of revenues the year before the IPO. So most companies are eligible, and of those eligible companies, close to 90% choose to do confidential filings. And confidential filings are more common among biotech and pharma firms. This is a finding by Dumbra et al. So they basically interpret this as evidence that, given that proprietary costs are likely more important concerns for biotech firms, the fact that more biotech firms are doing this suggests that the proprietary costs are an important determinant of why companies choose to do confidential filings. Now, the direct evidence, however, on what the benefit of the confidential filings is elusive because we don't really see exactly what is the benefit that the companies are getting from filing confidentially. Typically, the authors argue that the main benefit is to provide the companies with the option to withhold any disclosure in case the company decides to withdraw. So if a company does a confidential filing and decides to withdraw its IPO at least 21 days before the roadshow date, then it doesn't have to make any disclosure. It doesn't have to make any public disclosures. So all of the information it has remains confidential, basically. And this has been discussed as the main benefit. Now, in this paper, what we do is we want to, help the assessment of the efficacy of these confidential filings by focusing on a specific benefit, which is the non-shareholder litigation risk. So why do we focus on non-shareholder litigation risk? Because we argue that the non-shareholder litigation is a significant concern for companies that are planning to do IPO for several reasons. First of all, these are private companies that are planning to become public, and registration statements are the primary source of information for the new for the new investors. But it's not just for the investors. It's basically, once this information is disclosed, I think information is told to everybody, including competitors and potential other plaintiffs. So given that this much information is being provided, it basically gives the potential plaintiffs additional information about the company that they can sue the company on. And it also signals to the market that the firm is planning to grow and become more competitive. And this basically can hurt the other players in the same market, which can also give some incentive to sue these firms. And registration filings also indicate that the firms are incentivized to avoid any negative publicity more than before. Before, they were private firms, so they probably didn't, they probably don't really care about raising any new money at that point. And in the case of IPOs, they're planning to, they use this as a marketing tool, and they're planning to raise typical large sums of money. So during this process, they'll be more incentivized to avoid any publicity. Therefore, arguably, they'll be more incentivized to basically settle anything that can actually look bad during the IPO process. Therefore, if you combine these three factors, the non-shareholder parties are more incentivized to sue because they have more information about the company, and they know that this company is planning to grow, and they're more incentivized to avoid any negative publicity. So for these parties, basically the chances of lawsuits and conditional of finding a lawsuit, winning these lawsuits, is basically increasing during the pre-IPO period. And what we would argue is that if you make these registration statements confidential, then you can actually obscure the signal and reduce the time and information available for these parties to file a lawsuit. In terms of research design, what we do in this paper is we use a difference in differences model. And our first difference will be treatment firms versus control firms. The treatment firms are the firms that file confidentially after the Jobs Act, and the control firms will be firms that file for the IPO before the Jobs Act. And we follow Chapninsky et al. And use a propensity score matching and industry matching for determining the control IPOs. And our second difference will be a comparison of the pre-IPO period and a benchmark period. By pre-IPO period, we are basically meaning the time between the registration filing and the IPO date. And the benchmark period is the same length window ending 10 days before the registration filing. So we basically compare how does the number of lawsuits change between benchmark period and IPO period for treatment firms, and we basically compare it with the changes for the control IPOs. And we use two different models for analyzing this. We use a OLS model where our dependent variable is a standardized count of lawsuits. When we say standardized count, basically because the registration, the length between the registration length, the time between registration and the IPO date varies across companies, what we do is we count the number of lawsuits filed against each company during that period, and then we basically divide it by the number of days and multiply it with 90 to figure out what would be the average number of lawsuits they would face over a 90-day period if they faced the same rate of lawsuits over that period. And we alternatively use a Poisson model where our dependent variable is the row count of lawsuits, the actual number of lawsuits that are filed during the registration window, basically. And for that one, since the dependent variable is a count, we use the count model. And the model basically has independent variable for confidential, which is equal to 1 for our treatment firms and 0 for our control firms. And another indicator variable for pre-IPO, which is equal to 1 for the pre-IPO period and 0 for the benchmark period. And we have the interaction term. So our main focus will be on the interaction term, but we also look at what's happening for beta 2 in these models because it tells us how the number of lawsuits change for the control firms relative to the treatment firms during the pre-IPO period. Okay, so in terms of the data that we have, we are looking at a sample period between 2008 and 2014. Our treatment firms come from the April 2012 to April 2014. So we are basically looking at the 2 years after the Jobs Act, enactment of the Jobs Act. And for control firms, we use a 4-year period before the Jobs Act. And the IPO data is from STC. For the lawsuit data, it actually comes from the PACER, Bloomberg Law, and the state court websites. So what we do is we first identify the defendant firms through searching these sources, and then for all dockets that we identify, we basically make sure that the name of the defendant actually matches the firm that we have. And then we only focus on the lawsuits that are around the IPO, and then we basically read each remaining docket to ensure that the defendant name is correct, and classify the plaintiffs as business plaintiffs versus any other plaintiffs like individuals or non-profit organizations or government. So when we say other plaintiffs, we basically mean anything that's other than business. And then we identify the final disposition. Now, that step is a little tricky because if you have seen lawsuit data, they don't really, record this data for in a machine-readable format or for anybody who is actually not from law. So it's a little tricky to figure out what's happening with these lawsuits, and sometimes you don't really get the final disposition in the dockets. What we managed to do is we managed to identify about 87% of all of the lawsuits' final dispositions based on what's in the docket. The remaining observations we couldn't figure out because either the case got transferred to another court, and we just keep lose track of that case, or it might be in some cases ongoing, and in other cases it doesn't say what's happening with the case basically. So our sample size for the analysis where we examine the final disposition will be slightly smaller than our main analysis, basically. Okay, so let me get to the results. This is basically the number of lawsuits, new lawsuits filed around the registration period, the registration date. Date 0 is the date that the company files for its registration. And the bars basically show the number of lawsuits filed against the companies in our sample. And basically what we are seeing in this graph is up until the registration date, there is a relatively stable number of lawsuits over each window. And then once the companies file their registration statement publicly, this is the public registration statement date, what we are seeing is there's an initial increase in the number of lawsuits, and it keeps increasing for a foreseeable future, basically, which takes us to the point that there is a relation between the number of lawsuits that we are seeing and the public filing of these registration statements. Now, in the second graph, what we are looking at is something slightly different. This graph is actually centered on the IPO date instead of the registration filing date. And it's showing us the number of lawsuits for control firms. So these are the firms that did not file confidentially. And what we have here is up until about 270 days, we have a fairly stable number of lawsuits. And then about 270 days before the IPO date, we start seeing an increase in the number of lawsuits, and that increase continues up until 270 days after the IPO date, and then it stabilizes more or less. This is for control firms, and then let's see what happens for the confidential filers who actually use the confidential filing provision of the Jobs Act. And this is basically what happens. The gray dotted line shows those numbers. The confidential filers have a little bit of more lawsuits before the IPO compared to the control firms. But if you look at what happens to the number of lawsuits that they're facing up until day zero, the IPO date, it remains very stable actually. After the IPO, we still see an increase in the number of lawsuits, and these numbers become pretty similar between control firms and the treatment firms around 405 days after the IPO date. Now, this graph tells us one thing, that the control firms start seeing an increase in the number of lawsuits well before that the treatment firms actually start seeing an increase. And the other thing it's saying is that the number of lawsuits for the treatment firms are not increasing abnormally compared to the control firms after the IPO, which basically suggests that, first of all, some of the lawsuits are being eliminated during the pre-IPO period. And second, after the IPO, those eliminated lawsuits not really seem to come back, because we don't really see an abnormal increase in the number of lawsuits for treatment firms relative to control firms after the IPO date. So this is basically this graph summarizes what we are doing and what we are finding throughout the paper. And let me show you the statistical analysis that we have done, the models that I have just described. So again, we have two models. One of them is the standardized count model using OLS. The other one is the regular count model using Poisson. And in this table, basically, we are looking at two variables. First of all, we are looking at the pre-IPO dummy, which tells us how the pre-IPO lawsuits change for the control firms relative to the benchmark period. So during the pre-IPO period, control firms are basically facing about 25% more lawsuits relative to the benchmark period. And if you look at the interaction term, the confidential times pre-IPO, it is significant and negative, and it's of similar size, suggesting that the confidential filers do not see that increase in the number of lawsuits that the control firms are seeing. So basically, confidential filers have less of a issue with the number of lawsuits increasing before their IPO, in a sense. Next, what we do is we want to understand these patterns a little better. So we do two different cross-sectional tests. One of them is to see whether the change in the number of lawsuits is coming from the business lawsuits or from the other lawsuits. The argument here is that confidential filing basically hides information, the financial information, business operations information that can be actually useful, more useful, so to speak, for the business plaintiffs. So if I'm a business plaintiff, if I want to, if I'm looking for something to sue the IPO firm on, the registration statement basically provides me a lot of information in terms of the company's operations, perhaps the patents that they hold, and the profitability and stuff. So for that reason, we basically expect the businesses to benefit more from the publicity of the registration statements relative to the other parties. And by other parties, I again mean individuals like employees or ex-employees, managers, or customers, or government officials, for example, because some government agencies can sue the companies, and we believe that those parties would not really benefit too much from the registration statement itself, the information in the registration statement itself. So we will basically look at the change in number of lawsuits based on that separation first, and then next we will do another separation, and we will look at the intent of the lawsuit to see if the change in the number of lawsuits are driven by the legitimate lawsuits or frivolous lawsuits. And the way we will identify it is we will basically look at the outcome of the lawsuits. If the lawsuit ends in defendant's favor, previous research basically suggests that that's more likely to be a frivolous lawsuit. And if it is basically settled or ends in plaintiff's favor, then we will classify it as a legitimate lawsuit, basically. So results from here, from these analysis, first of all, we find that the results are mainly coming from business lawsuits. And although we see an increase in the number of other lawsuits, the confidential filing doesn't mitigate this increase, basically. So confidential filing is really only effective against the business lawsuits. That's our first finding. And then in terms of the intent, what we are finding is that we actually find evidence for both an increase in frivolous lawsuits and an increase in legitimate lawsuits before the pre-IPO period. Arguably, the frivolous lawsuits are, a little more, basically. There's a little more increase in the frivolous lawsuits during the pre-IPO period. So filing confidentially eliminates those lawsuits. This is one of the benefits. Of course, in the process, some of the legitimate lawsuits seem to be also getting eliminated. So therefore, we cannot really make a welfare statement in terms of the confidential filings are good or bad for the whole, everyone involved. But what we can say is for the firm, for the IPO firm, it actually leads to a decrease in the number of lawsuits across the board. So it's actually beneficial for the firm. Now, one last thing, basically, we want to see if the lawsuits are eliminating lawsuits is kind of beneficial. So what we do is we try to measure the loss due to the lawsuits based on the underpricing of the IPO. So what we want to test is if you see more lawsuits, does it actually translate into greater underpricing later on for the IPO? And in that analysis, basically what we see is in general, lawsuits don't really affect the underpricing, but in more specifics, the business lawsuits actually have an impact on the underpricing. So firms that face one additional business lawsuit actually face about a 6% increase in their underpricing. So our argument here is by eliminating, one of these lawsuits, the companies can actually save up to 6% of underpricing. So it's actually beneficial for the firms to eliminate these lawsuits. We did a bunch of robustness tests, but I'm not going to go over them in the interest of time. And then just to summarize, in this paper, we ask two questions. First of all, does non-shareholder litigation risk increase ahead of IPOs? The answer is yes, up to 25% more IPOs we see before the IPOs. And we also find evidence that by filing confidentially, the companies can actually eliminate their lawsuits, especially from other businesses, and they can also eliminate some of the lawsuits that actually are for opportunistic reasons. And in terms of implications, our findings suggest that there's a significant increase in opportunistic non-shareholder lawsuits prior to IPOs, which we believe is of interest to investors and regulators when you're trying to understand the value of a firm, and investors basically needs to be careful in terms of how they value these lawsuits, because it seems like some of these lawsuits at least are opportunistic rather than anything else. And we also identify a material and unintended. And the reason we say unintended is because in the legislation, there's no, in the determination of the Jobs Act, basically, there is no discussion of these lawsuits. So we're basically saying that one of the benefits of the confidential filings is to reduce these non-shareholder litigation risk. And for research, basically, we are identifying a specific and quantifiable cost of disclosure, a proprietary cost, actually. And we're contributing to the research on non-shareholder litigation. There has been a significant increase in the number of papers, especially around patent litigation lately. So ours is a little more general than patents, but it basically covers It's basically in that literature. And finally, we are looking at the interplay between litigation risk and disclosure. And prior research also looks at this relation, but they look at it from the shareholder perspective. And for public firms, we are looking at that from the private firm perspective, and we are looking at the non-shareholder litigations. So thank you so much. I ran slightly over time, so apologies for that. And I'm looking forward to the discussion and your questions.
Thank you very much, Bugra. You were actually spot on time because I took a few minutes in the beginning. So yes, so we can move to Audra Boone from Texas Christian University with her discussion. So please, you have 15 minutes.
Okay, well, thank you again very much for the offer to discuss this paper. I found it really interesting. And Bugra, you did a great job presenting the paper. I thought it was really clear. And so let me dive into this. So just to get a little bit of background, you did a great job on this, but as part of initial public offering, firms have to file a registration statement. Typically that's in an S1. And it results in a significant quantity of disclosure coming at investors. And this includes financial statements, the firm discusses risks, it presents its governance structure, and also things like material contracts. And I'm going to come back to that point in just a little bit. The information that comes out in this registration statement can reduce information asymmetry for investors and can help with pricing, but the downside of it is that it can also reveal proprietary information to rivals. So this is a big drawback for firms. So as we noted as part of the JOB Act, emerging growth companies can confidentially file the S1 with the SEC, and ultimately all the information is disclosed. It just delays when this information is revealed. So during the sample period, it was about 21 days prior. Actually now it's about 15 days prior, so it's even more. So what this does is it's less time for both investors and rivals to process the information ahead of when the company goes public. Now, ultimately, firms want to avoid the risk of a failed offering. And my definition of a failed offering is going to be either with having to withdraw the IPO or having the price drop after the offering. And these pre-IPO lawsuits can raise uncertainty for investors and can generate negative publicity, potentially increasing the likelihood that this happens. So in this paper, right, they note that plaintiffs could opportunistically file lawsuits just prior to an IPO. And to me, this is really interesting because almost all the literature on IPO is on shareholder-related lawsuits. There's some nascent literature on patent trolls out there, but there's really not much in this space. So the paper posits that firms utilizing confidential filings have reduced pre-IPO litigation risk because there's less time for those potential plaintiffs to review the material and file a lawsuit based on that information. So they expect that such pre-IPO lawsuits are based on business information and are meritless. In other words, they're more likely to be disposed in favor of the firm that's going public. And as you noted, the sample period is January 2008 to April 2014. So you have both pre and post Jobs Act IPO firms. And the majority of the tests use a propensity score match control group of firms that filed IPOs prior to the Jobs Act. Again, you did some robustness using other control groups as well. And ultimately, the evidence supports the notion that limited information ahead of the IPO from confidential filings reduces litigation to these firms, but the trade-off is that it could increase underpricing. So not knowing much about this, I did the same thing. I just go out and I Googled, like, well, what is going on with this? How much is this happening? And again, it's hard to find things that aren't related to shareholder lawsuits related to material that's disclosed in the IPO, but it wasn't hard to come up with a lot of examples. So the first three that are listed here are things I think would probably be captured within your sample. Again, sometimes these are outside of what you're doing, but you can see that they include claims like patent infringement, Spotify with music publishers claims that they don't receive sufficient royalty payments. There's trademark infringement claims. And the last two on Uber and WeWork are some things that recently came out, but they're not necessarily from businesses, right? Some are from employees that were claiming, like, again, that they want to be recognized, or that I should say drivers that wanted to be recognized as employees for Uber, and for WeWork, that claiming that there was a toxic environment. So there certainly are a substantial amount of these lawsuits happening, much more than I was aware of prior to reading this paper. So my first big comment is that the paper's premise is that opportunistic lawsuits are related to information disclosed in the registration statement. And I certainly think this is plausible. It would just really help me personally if the authors could bolster this claim with some supporting evidence. So then you have to ask yourself, well, what kind of supporting evidence could they look at? One of the things you can do, the lawsuits mention information that would have been revealed in the filings. Is there something in there that could link it to that information? Another thing that potentially could help support this is whether or not businesses list litigation risk in their registration statement. So again, I went and I started looking at S1 filings and seeing, well, maybe every firm lists litigation risk. And I actually didn't find that to be the case of just some recent IPOs. Some of them were more talking about, spent more time in the risk section talking about potential litigation than others, or revealing proprietary information. The other thing I thought that you could also include in this analysis that's kind of more indirectly related is whether or not the lawsuits are related to the amount of funds being raised or the proposed use of proceeds in the registration statement. My thought is that one of the things that gets revealed is, again, how much money I'm raising and what I'm going to do. And maybe that's also what triggers people. And if I have raising more cash, or that's going to be more money that maybe they could use to settle the lawsuit. Or again, if they're going to use the proceeds for specific projects, that could indicate they're going to be more competitive, which could lead their rivals to want to file these lawsuits. The other thing that EGCs can do is they can alter other aspects of their disclosure, such as the length of historical financial information, where they can provide 2 years rather than the standard 3, and they also don't have to provide as much on the compensation front. My thought was, if firms also use these options, it would just further indicate that they want to reduce the pre-IPO public information. Again, it's indirect evidence, but maybe get more supporting evidence along those lines. So I mentioned earlier about the exhibits, and this is something that I really think you could do more with. I think a lot of the really valuable information is in these exhibits that are attached to the S1, and particularly exhibits 10.x, whatever it's a 10, those are material contracts. And I think that's where perhaps, again, if people are really using some of the information, that's where it's going to be gleaned. And as you noted, thank you, for citing some of my work, but on these things, but firms can request confidential treatment of competitively sensitive information, which allows them to redact specific content from exhibits. And they have to go to the SEC and show that they could incur material harm to do this. So my thought is that if firms are employing more of these CT orders, it could indicate which firms are most keen to avoid publicly disclosing certain information, and maybe are at a greater risk for litigation. Of course, at the same time, if they do the CT orders, that's less information that firms might be able to use or potential plaintiffs able to use to file a lawsuit. And then as I was thinking about this, when I was doing that project, it was basically pre-Jobs Act firms. And one thing I noticed is that they would file their S1, but a lot of times for that first S1 came out, you did not have access to the exhibits. It would say to be filed at a later date. So then when they did an amended filing down the road, sometimes it was a month or 2 months later, then you would actually get the information. I think part of this is related to that confidential treatment process, because they were waiting to see if they got approval. But my thought was these firms were still effectively able to reduce the time that key contracts were revealed to the public before the IPO. So they kind of were able to utilize that ability. And I wondered maybe if these firms would be a natural comparison group who are also able to reduce the litigation risk. So it might be kind of another validating test for you to do. And then on the underpricing front, one thing I was wondering is if, so the way you have it is a confidential filing reduces business lawsuits, but of course confidential filings also leads to higher underpricing. I'm not sure in your regressions in table 6 if you can separately tease out the effect of lawsuits with your current specifications. Because of the relationship between those two variables, you might have some multicollinearity. So one thing that you could just simply do is divide the sample by firms that file confidentially and those that do not, and then just rerun the underpricing test. And that way you don't have that interaction effect going on. The other thing, I realize you're following some of the Shaplinsky paper. When you're using this control group, it still made me wonder whether or not there's some problems in terms of time variation, both in terms of the types of firms that are going public. And you noted that, for example, there's more biotech firms afterwards, which are very different and have a different set of risks and information associated with them. And also there's time variation in the degree of underpricing. So you know, just kind of might want to think through that a little bit more, whether or not some year and industry fixed effects might be a better strategy on some of that. The sample ends in 2014, and I wouldn't normally want to ask people to go out and do more data collection, but one thought is that there were new rules in 2017 that extended the ability to confidentially file to all firms, not just the EGCs. So again, maybe this setting could help isolate the effects of lawsuits and provide more robust evidence. But I suspect perhaps going out and getting the lawsuits was a very costly endeavor for the authors. So I'm cognizant of that cost. One other thing I wondered is whether or not the pre-IPO lawsuits lead to longer times between the first filing or when they register and when they go public. And to me, this is an additional cost that you could put into this paper because a longer time to completion just increases the risks. Right? Economic conditions can change, and as we all saw recently, right, when things are going along, all of a sudden something happens and you could lose the ability to go public, or other unfavorable information can emerge about the firms over this time period. So if also these firms ended up having that longer time, that's to me, that's also a cost. Another thought I had is why firms would not use the confidential filing option, right? Because, so in other words, what are the trade-offs? And I think maybe you could just add a little bit more to this to your specifications. So some firms consider both an outright sale and an IPO simultaneously. And in that case, these firms might not want to confidentially file because they want to increase the transparency and generate interest. And so that's something else along those lines. Firms that might want to get more publicity might not want to avail themselves of this, even with the additional risks. And then at the end, just a few other comments. I also wondered, I'm not sure this is within the scope of the paper, but you know, Ben, how much does this idea of litigation actually deter firms from even choosing to go public? There's a recent paper, Jonathan Bugra is one of the authors on it, that showed in the context of shareholder litigation, that might be what leads firms to going private. But I found an interesting article about Alibaba ahead of their IPO, where they started applying for a lot of patents and bought up hundreds of others in order to try to mitigate this potential for lawsuits ahead of their IPO. So I thought that was another interesting strategy, right, where firms could mitigate their risks on that front. And then just finally, a couple things, clarification. Did the business lawsuits include patent infringements brought by firms but not patent trolls? So again, maybe just add a little clarification there. I'm also a person that likes a lot of detail in there, so I would like kind of more detail on the claims of the lawsuits. You know, what kind are they? Are they the trademark, patent, you know, other types of things, and maybe a breakdown by industry would be useful as well. And finally, according to my reading, the definition of legal merit, one, I thought it was sort of the is a settlement. One that has stronger legal merit or not. And the only reason I was thinking about this in terms of a settlement is I worked on a case for a company that had gone private and then wanted to go public again. And they had ongoing litigation. And even though I thought, because I was working on their side, and I think the lawyers thought that it didn't have a lot of merit, they just wanted to settle it in order to get beyond it and reduce that uncertainty ahead of their IPO. So just, you know, something to think about on that front. So overall, this paper reveals a potential added benefit of confidential filings that has not been explored in the literature. I certainly learned a lot. And I think actually the way you presented the paper, I thought illustrated your contribution more than the way the writing in the paper currently is. So I think you could do more on that front to really emphasize how new this is. And the benefit, as you know too, is that the findings could help lawmakers and regulators develop better policies to encourage firms to go public. So that's why I think these findings are really important. Developing a stronger link between the information, the registration, and the lawsuits is going to help bolster what your findings are. And overall, I really enjoyed the paper and learning about these lawsuits, and I look forward to seeing future iterations of the paper.
Okay, thank you very much, Audra, for the discussion. Bugra, would you like to take a couple of minutes to respond before we open for Q&A?
Yeah, sure. Thank you so much, Ozel, for these are very detailed comments, and there are several of them we have not heard from other commentators so far. So this is really great to have these comments. In terms of your suggestions, I think many of them are valid. Obviously we can basically do a lot of additional twists this thing, and I mean, in general, like such as separating samples for confidential or underpricing versus not. These are actually some of these things that we have done that we haven't reported in the paper. Maybe we should, because I totally understand your point about that. In terms of going and collecting data, for the 2017, I think that's the toughest one, because well, I should say this, like it would have been very tough if we were doing it from scratch. Now that we have done it once, I think it will be a little easier because we know where to look at it, but it will still take a little bit of time. But that for sure is like something that we can try to do it to see if if it's kind of reasonable. If it will take reasonable time, we can definitely add it to the paper. I think it would be a nice addition to the paper. I mean, other than that, like all of your comments, you have several of the comments, so I don't really want to go over one by one. And but these are really actually helpful comments, so we will definitely take a look at them in more detail. And thank you.
You're welcome.
All right. So in the meantime, I got a couple of questions from Matt. Would you like to engage in the discussion?
Yeah, I can read them. I just wasn't sure what you wanted. Yeah, so I guess I have two questions. One is more procedural. Do firms ever announce that they're going to make an IPO, but they still do not release their S1? Like these confidential treated firms still make a public announcement that they're planning an IPO.
Yeah, so it does happen. It actually was one of the things that we were concerned a little bit. So what we did is we actually, for each IPO firm, we went and checked when did they actually publicly announce themselves. Did they ever do it before filing for the S1? The famous example for that one is Twitter. What they did is the day they actually confidentially filed their IPO, they went out and tweeted that they actually filed confidentially. But it turns out that we only have 5 observations that actually did this, at least during our sample period. Maybe later on it changed, things changed, but during our sample period we only find 5 of them. So we thought that it's not a major concern for basic or analysis.
Yeah, I was thinking there might be like some heterogeneity there in actual announcement versus the confidential S1, because then you might have lawsuits that try to discover the financial information in discovery as part of the lawsuit itself.
I mean,
that hedge with your lawsuit.
There are 2 things. So first of all, the registration statement provides information. So information is obviously an important thing for filing lawsuits. But the other thing is registration statement gives a signal, basically, that the company is trying to do an IPO. So basically, by publicly announcing it, they got rid of the signaling aspect of it, but they still can hide the information for long time, basically.
Yeah. So I also had a second question that was kind of prompted by one of Audra's comments. Could you also further break down, I know you break down plaintiffs by business and other. Could you further break down business by those who have established contractual relations with the IPO firm? Did you consider doing that, or?
We can try to do that. In fact, like we actually try to do separate business lawsuits a little bit. To Audra's point, actually, not all of these are actually patent trolls. You have several of them as competitors that are actually filing lawsuits. When I say competitor, they're in the same industry, basically. So we don't exactly know to what extent they're directly competing in terms of the products. And we have several other companies that we couldn't identify them as patent trolls, or we couldn't, well, at least they don't really seem like patent trolls, and they don't really seem like competitors. But we didn't really look at what their relation with the company is. And, in some cases, it's a little difficult because the company names are not always written in full. Sometimes they basically say, they shorten the company's name and put an ink at the end of it, so you can know that it's a business, but you don't exactly know what that company is. But we have done that.
Okay, thank you.
Thank you.
Okay, actually, I had a question myself, but before I ask it, I'm also going to launch a short poll in the background about today's webinar, so you can just answer. So I really found that notion of trade-offs interesting that Audra had in her discussion. So if it wasn't a discussion, I would have actually asked myself. So I mean, but I guess it's tricky because you sort of observe these different outcomes or effects are bundled together, like less visibility but less lawsuits. So I was just curious if at all you could try to sort of disentangle them, because it is, even when you start your paper, that you have these 2 competing effects that you would think IPO is about increasing visibility, but then so many firms file confidentially.
Yeah, so basically, I guess the proof is in the pudding. So if it was not beneficial for the firms, the companies wouldn't have done that much confidential filing. So the benefits must be outweighing the costs. And what we know is, like, so far we know that the costs are pretty high based on part-et-al paper and Japanese paper. They're basically showing that confidential filings lead to somewhere around 13 to 14% increase in underpricing. And given that, since the companies are doing more confidential filings, basically our point is more like there must be some benefits. And yes, the option to pull out from the IPO, to withdraw the IPO, can be beneficial for the companies. But if you actually look at the data, not that many companies withdraw during the process. The estimates are between like 25 to 40%. But given that about 90% of the firms are actually doing confidential filing, so our point is basically there must be something else that's actually helping these companies, benefiting these companies. And in that respect, basically, ours is like identifying one benefit. There might be other benefits, obviously, so we can only capture one in this paper. And our contribution is only like showing one thing that's actually benefiting these firms. But we think that that's kind of beneficial for the regulators to know also.
Okay. So then the other thing I was wondering, so maybe I didn't catch it from the presentation, but these confidential filings, do they remain sort of confidential forever, or is it that after the IPO you can actually see them and compare what do these firms file compared to those that file openly?
Yeah. Before, as Audra said, during our sample period, it was 21 days before the roadshow, the companies must make it public. Then it became 15 days before the roadshow that they must make it public if they proceed with the IPO. If they don't proceed with the IPO, however, if they decide to withdraw, then you basically don't see those filings at all. Like we have tried to get the data from SEC. We have contacted them to see if they can share with us like details of the withdrawing companies, but basically it's not covered under FOIA, so they don't really share that type of information. I mean, obviously there's a reason why it's called confidential filings, I guess, so they don't really share that.
Okay, thanks. Do we have any more questions? So now I guess you can just speak up spontaneously. Would you like to ask any question? Okay. Meanwhile, just let me remind you that the series continues. So in 2 weeks, we will have Diego Garcia from University of Colorado presenting. So stay tuned for updates. Okay. So looks like there are no more questions. So thank you very much for the insightful presentation, discussion, questions. And thank you for joining for the webinar. Good to see you.
Thanks. Enjoyed it.
Thank you. That's good to hear. Thanks.
Yeah. Thanks. Bye.
Bye-bye.
Thank you.